the meantime. 5, 4, 3, 2, 1, and we are live. Good evening and welcome to another live episode on Disqualified Dads. It is Sunday, 8 p.m. You know what time it is. We are here as promised every Sunday, 8 p.m. We ain't messing about. Joining me will be my co-host, the best in the game, via his mobile phone, because that's how committed he is. He's so committed to the cause. He's joining this stream via his mobile phone because of the area of the country he lives in. They have no internet. They haven't discovered internet. They don't know what it is. They don't know what it is. They're lucky they got electricity, clearly. You know what I mean? Just about got chargers for their phones. But yes, he's the best in the game, the best Mackenzie around. And also, we know he's good because he's got haters. We've got haters out there spreading hate about us. So we know we're good. We know we're delivering. We're here. We're doing this. You know what I mean? And I have to say, before we continue, I just want to highlight that I'm really grateful to God for making me such a specimen. I mean, I look good. I have to say, I look good. Damn,
yes. Well, beautiful. It's beautiful. It's beautiful. I'm just delighted to be able to look at you. It's beautiful. It really is.
I know you are. I've seen you watching me. I've seen you.
Steady now. Steady. Let's not go down this theme. This could get very messy very quickly. Let's not do that.
All right. Listen, we've got Mr. Darren, who's been waiting patiently. So let's not mess about. I'm going to bring him on straight away. Darren, I'm going to bring you on. Right, Darren, welcome to the show. What do you need? Talk to us.
Yeah, a question for Mr. Ryan.
Hi, Darren.
Form E has been exchanged and swapped. Now it's questions time now. I've noticed in her Form E statement she's lying. She's saying that I wasn't living with her until after 2016. Now, I can prove I was living with her from 2014, only 6 months after we split up. She sorted out my car insurance for me in 2015 and my personal liability insurance. And she put my name and address on the policy and then forwarded me the policy while I was at work in 2015. That's one form of proof. Also, there's MSN messages, direct messages between her and bank statements. I was working for Barrett's, Derek Wilson Homes, and a few other building contract companies, being a bricklayer at the time. So my question is, how do I put my questions towards her? How do I put my questions?
Bluntly is the answer there, Darren, to be perfectly honest. If you've already had the 4B, you've already seen some issues within it, such as this issue over date, then you make your questions blunt and clear. Just say, please explain why it is that you have lodged a date of 2000. What did you tell me? 2016. You've lodged a date of 2016 as the start of this relationship or the end of this relationship. And I contest that. Please demonstrate, what makes you believe that is the date you want to go with. Just out of interest, what is the reason why she would want to put a later date? What's she trying to achieve with that?
The thing is, I signed a house transfer document in 2014. I was mentally not well. I went in hospital, had a nervous breakdown as such. I wasn't represented. But we got back together 6 months later after my father died. She wanted to be friends and was love bombing me and everything. We carried on living together for 10 years and it's in court now, like I said before. The judge at the last trial said I have to receive something because we both signed a document in 2018 for a new fixed rate mortgage. So he said to her, more or less, that because you've entered a new document with him in 2018, it makes the 2014 one void. He gave us a chance to go outside and make offers. I made her an offer. She refused, and so it's going to final trial now.
Okay.
That's where we're at. So she's
Okay.
lied on her Form E, and I just want the judge to know that she's lied, and I can back everything up with proof.
Okay. What will happen then? Is this the first round of questioning that you're about to do?
Yes, we've got one in July following, which is a live one with the judge included. And then the August 6th is the final hearing.
Ah, right. Okay. All right. Right. So what I suggest you do, as I say, your questions, if it's your first round of questions that you're asking,
It's gone dead.
and then what will happen is, I think we dropped out for a minute there.
Dropped out, yeah,
I'll just repeat that for you, Darren. So your first set of questions, very concise but very clear. Did get to the heart of what it is you're trying to ask. So please explain why you have put the date of 2016 in relation to this relationship, because the way the questioning process works is when she replies back with whatever it is she's going to say, you have another option to challenge that, and it's referred to as the schedule of deficiency. So you go back and say, in respect of your answer to question 1, for argument's sake, let's assume that is the question about 2016. In respect to your question, I can illustrate with very clear evidence that the answer you have provided is not the case. And then in your position statement submission to the court ahead of the next hearing in July, I think you said, you say to the court, this wife, ex-wife, is lying. She's offered up 2016. I have evidence which I've attached to this position statement to demonstrate that that's not the case at all. That this relationship was alive, in 2015, 2014 with the car insurance, etc., etc., etc. Offer all that up to the judge in order to clarify the position for him, and then it'll be interesting because he'll then say, "Well, wife, what have you got to say about that?"
Should I let her know what evidence I've got in the questions? Or just keep quiet?
I would just, in the first question, I would just say, I have evidence that suggests otherwise, and leave it at that. Okay. And see what she comes back with.
Don't be specific.
Yeah. Just see what she comes back with.
And is lying on a Form E a serious offence as such?
The family court works on a belief that we call the Lucas direction. And the Lucas direction says that the family court accepts the fact that people lie. What they don't accept is that people lie about absolutely everything. So has she lied on a Form E? Yes, you tell me she has. Is the court going to be concerned about that? They'll be concerned only if it's flagged up to them. Because the courts expect people to lie. That is the nature of family court. Nobody would go there and be wholly honest because invariably they're going to lose. Unfortunately, people do fabricate information. People do manufacture stories, create false narrative in order to achieve the position they're trying to achieve.
Can I ask another quick question?
Of course.
Yeah, go ahead. Take your time.
I'm worried about the whole costs implied because she has a barrister and a solicitor. And is £68,000 in debt. And I understand the judge recommended I received £30,000 at the last trial as an offer. Now, I'm worried that if I get £40,000, is the judge going to apply her costs onto me? Which I don't think it's fair because I've had to do all the legwork myself, worry. She's chosen to have her barristers. She could have done it herself. Plus, the recklessness of having such a small pot, the recklessness of running up them costs is just ridiculous. I'm just worried that the judge is going to pass them on to me.
The judge cost orders in financial matters are getting less common. They used to be very common, but they're getting less common now. Judges now tend to be of the opinion that if the two of you want to fight, pay your own costs and fight. And it's disproportionate for one party to have to leave the room carrying the other party's costs. Having said all that, if the judge finds grounds to make a cost order, either way, you to her, her to you, they will make that order. But as I say, it is getting rarer. And it sounds to me that the obvious question is, if mother is thousands of pounds, or wife rather, is thousands of pounds in debt, how is she paying for the representation she's currently getting?
It's all on credit card.
Oh, okay, she's on credit card. Well,
£40,000 on 4 different credit cards.
Good Lord. What does she work? I'm just being nosy now.
She works. She works for CTEC in the mental health regional manager or something, and she earns £56,000 per year.
Okay, but £56,000 a year when you've got a personal debt of £60,000 a year is not a good place to be. The court will at some point will become aware of her personal debt, because she is going to undoubtedly drop it on the table and say, "Oh, woe is me." The court's view, well, there we go. The court's view will be, well, we didn't ask you. Nobody asked you to take the route you've taken, and unless there is specific grounds for us to unload costs on this husband, we're not going to do so. If mother is wife, I keep saying mother, if wife is directed to give you money, is there a property where that money is going to come from?
It's the house. She's making a case, but she needs a house to the judge. She's making a victim statement of everything, of how poor she is and how neat she is. She's laying it on thick.
Yeah.
How she's in debt and everything.
Okay. The one thing, a mechanism I'm using more often these days, because lots of people are in that position where they're in debt, and even if they get directed to part with some money, they haven't got it anyway. So the one option that I'm using time and time again, and I've mentioned this to you because it's a very sensible one, is advising the court that you will put a charge on her property, which she will pay for. And so you ask the court to make the court order that the charge costs about £2,500, puts a charge on the property, which essentially says that when that property is sold, the first payment out against the property comes to you because you've got the charge on it.
But won't the court decide that on the final hearing?
Yeah. I'd say if they realise that I mention this to people because sometimes courts forget about the fact that charge is an option to them, and they kind of go down the, oh well, she's got no money, not to worry, there's nothing we can do about it. Yes, you can, because you can instruct. Yeah, you can you can ask the court to say direct a charge, so I can place a charge on her property.
Brilliant.
And then when the property's sold, I will get my money.
Brilliant. Yeah. I'm sorry. It's just, I'm just so worried. And when you're up against a barrister and a solicitor, it's hard.
It is. No, I appreciate that, because I say, one's a gunslinger and the other one's an idiot. So, I appreciate that.
Okay. All right. Thank you, gents.
Darren, if you get any more questions, tune back in next week. We're here every week, so if you get any questions, dial in next week and we'll help you, support you all the way through. Yeah,
I'll keep you informed, you guys, and hopefully, when it's all done, if I could, send you both a gift.
Oh, good stuff. Yeah, we like that. Listen, I have no issue. I just want to make it clear to everyone that's watching and listening. I have no issue with gifts. I have no issue with receiving gifts, presents, money, super chats. I'm all for taking, yeah. So yeah, don't feel bad about it. Just send it. I'll accept. Don't worry. Darren, all the best. Yeah, we'll speak next week.
You too.
Yeah,
thank you, guys.
All right. Take care.
All right, guys. There's 18 people watching. Can I please request humbly that you all click the like? Well, there's 19 watching now. Click the like button. And this is a good point. Mr. Ryan, there's a pit. I need to show you guys something I saw the other day, and I need to show you lot what I found. So watch the screen. The other day, Mr. Ryan went out for a drive, and look what we got here.
Oh, Lord.
Is this how you park? I know you went to Waitrose.
Well-
I know you went to
well-
shop. Is this how you park?
Well, I don't want anybody to damage the car, do I?
See, I know you're a hot shot Mackenzie, but come on, man, like it's taking the biscuit. This is look 4 bays.
I just don't want people to damage the car. That's all it was. It was just I appreciate it's not the best parking in the world, but the car was okay. So there we go.
Guys, this is why he's known as Bentley Ryan. Bentley Ryan. That's why he's known as Bentley Ryan. See? Right. Question. Right. Let me let's tackle a question now. Enough of this messing about. Right. Mr. Kudo. Hi guys. Firstly, thank you so much.
While you're
all you do.
Before you jump into a question, I must, while I remember, and I'm only doing this while I remember.
Right.
I had an email from Nick Hine.
Okay.
And we're going, oh, that's great. Nick Hine is a father going through family court in Australia.
Oh yeah.
And he sent us a note to say that he wished our service that we do was available in Australia because he's struggling. And I just wanted to say, if you're watching this evening, Nick, greetings from our side of the world. I trust everything goes well for you in the end, and I appreciate the frustration. And I also wish that we could offer this product in Australia, but unfortunately we cannot.
Yeah, sad. It's actually quite sad to know that we can only offer this service really in England and just cover England. I mean, it's a big enough task in itself, but it is a shame, really. It is a shame. But Nick, listen, key is Nick. It's your mind. It's all in your mind. It's the mindset. If the why is big enough, the how is easy. So if you're determined enough, you hit the books. It can't be that complicated. It can't be that much different, and it can't be that much complicated. People just find it daunting and think it's really complicated. But start reading the books, start checking it out, start getting information together. Perhaps you'll be the guy that starts the Mackenzie service in Australia. You could be that guy. That could be you, Nick. So, maybe look into it a bit more and keep us posted on your situation. Right. Can we tackle one or two? Okay, before I bring in these questions in the comments, let's talk about the situation. So look, someone I know has found himself in a situation. So let's break this down for a minute.
Go on.
He has discovered a letter that was meant for his partner. And it turns out he's discovered that partners applied for an NMO and an occupation order. Now, they're still in the family unit. They're still in the home. But he's discovered that she's done this now. So it's not been served yet, but he's seen the documents from the court or the solicitor or something to highlight that he's got it coming his way. Now, it's not been served yet. What can he do? What are his options during this period? I mean, it's all a bit sort of an awkward situation, really.
It is a very difficult situation. If that's coming your way, the obvious thing to do, and it's just about being obstructive, but the obvious thing to do is to counter apply. So you also make an application for a non-molestation and occupation order, against the other party, because that presents the court then with a real problem when they have both parties cross applying. That causes a major confusion in the family court. But that's an obvious thing to do because that disrupts the process. If you make an application as well, outside of that, you really are in a position where you've just got to wait for that court date to bounce on the carpet and then deal with it.
Mr. Ryan, hello. Right, Mr. Ryan's phone's obviously playing up again. Yeah, so look, this is exactly what I suggested to that fella. Now, if you're listening, I would say we'll arrange a call. Yeah, you broke up there, Mr. Ryan. Yeah, so look, the key is, this is why I advised him as well. Put a counter one in. Yeah. You got to get there first. Counter it, put it in, get your evidence together, get whatever you have, get organized, basically. And that was my suggestion. So look, we'll speak to that chap tomorrow, and we might have to submit one on his behalf and use the evidence he's got to then counter against Hernan Mo, and hopefully his one sticks ultimately. So, but yes, we will. If you're watching, Mr. Ryan will touch base with you tomorrow, and we'll tell you what the steps are to do this and how we go about it and whatnot. Yeah. And listen, like I told you, stay strong, stay cool, stay calm. Don't do anything rash and don't do anything stupid. Right, that's that one tackled. Right, can we jump onto Mr. Kudo?
Off we go.
Right, Mr. Kudo. I haven't seen the name before. Welcome to the channel. Just so you know, Mr. Kudo, we are here every Sunday, 8 p.m. live. Make sure you join in. Make sure you tune in. We will help you get through this journey. Hi, guys. Firstly, thank you so much for all you do. It means more than you will ever know. Some of us are only here because of the help you have given us. You know what? That touches my heart. I appreciate that. Thank you. And this is why we're doing it. This is exactly why we're doing it. All jokes aside, we are here to help people like you get through a difficult time. I finished a fact find and all allegations were not proven. However, the courts have not ordered contact despite no safeguarding issues. Kafkas said no contact in case it has to be stopped at the fact find. Please help. Great question.
Right. Okay. Right. Okay. When we say that not all the allegations were proven, I surmise that means that some of them were. Hence the reason that contact is being held off whilst we consider what to do next. Let's have a look. Kafkas have said no contact in case it has to be stopped at the. Yeah. Okay. That's fine. Now that the fact find is over, am I right in assuming that the judge has now decided that Kafkas are going to do a Section 7 to explore the findings that have been made and decide the impact of those on the children? If you just want to sort of answer a yes or no on that one, Kudo, for us, that would be helpful. I surmise that is most likely to be the next step. If it is, then, and I'll just carry on chin-wagging until you reply to us. But if it is, then what will happen is that Kafkas will contact you and Mother, interview you both at length, also engage with the child. And we don't know how old the child is at this stage, but engage with the child if he or she is old enough, and then arrive with some recommendations that they will hand out at the next hearing.
Okay, perfect. Let's move along. These questions are starting to pile up. The viewers are piling in. Guys, can also someone confirm in the comments that you can hear me clearly? It's not too loud and it's not too low and it's clear. Someone just confirm that in the comments in the meantime, please. Right, my old mate, Stray Dad. Good evening, guys. Hope we are all well. I just want to say, Stray Dad, look at me. How can I not be well? Just look at me. Great, grateful, blessed. Alhamdulillah, truly blessed. Anyway, moving along. Have a fact find next week. Any tips to prepare myself? Anything I should ask for in the hearing? Great question, Mr. Stray Dad. Well, once Mr. Ryan sorts his 5G out now, he'll answer that. Are you back?
Yeah, quite. Yeah. So the phones know better than the internet this week, and I don't know what's happening. Right, okay. So your fact find next week. Tips to prepare. Yes, the obvious tip to prepare, Stray Dad, given that we had a conversation earlier on in the week, is give me a ring. Give me a ring tomorrow, because that's going to be much easier.
Stray Dad, call him.
Call me tomorrow. That's going to be much easier. We had a conversation earlier on in the week, you see. So,
okay, fair enough. But I just want to highlight, Mr. Ryan, tomorrow is bank holiday. Are you working tomorrow?
I work every day, 7 days a week, 365 days of the year.
Exactly, mate. Some of us are just killers. 365, we're here. Do you know what I mean, guys? We are here, 365. We don't live this civilian lifestyle. Do you know what I mean? We're out in the trenches 7 days a week. Right. This is a nice, straightforward question. Mr. Lewis Henriksen, what is a costs order?
Okay, Louis. A cost order is where the court decides that one party is going to pick up some or all of the legal costs that have been experienced and racked up by the other side. The reason they do that in a child matter or a financial matter is because the court believes that one party has not played quite as fairly or engaged quite as well as they could, and consequently the judge wants to punish them, for want of a better word, by imposing a cost order. They're very rare in children's matters. As I was saying earlier on, I think I was talking to somebody earlier on. They are getting rare in finance matters, but they are still around. So that's what it is. Somebody is going to pay somebody else's legal costs.
Right, Mr. Ryan, we have another live caller. I'll bring him on.
Okay. Righto.
Right, Mr. Harry,
Hello,
can you hear
can
us?
you hear me?
Yeah, we hear you, bro. We hear you. What's your question?
Hello,
Hello. Yes, we can hear you.
hello.
Harry, we can hear you.
Hello?
The audio issue is on your side. Can you hear us? Harry? Yeah, he's got audio issues. Harry,
Hello?
fix your audio issues, Harry. We'll bring you back on, yeah? Harry, can you hear us?
I can hear you. Can you hear me?
Yes, we hear you. We hear you. What's your question?
How are you? No, I came on before. I just can't come on now because I think the ex watches it. My question is my non-molestation's up today? I think you know who I am. I found the trick for the legal aid.
Oh, yes, we
Yeah,
remember.
Yeah. Carry on, Harry. I remember you.
What's happened is my non-molestation's up today. It's
Okay.
over. I don't want to speak to the ex-partner. I have no intention to. However, so my court order states that my contacts need to be supervised. Do I have to pay a professional supervisor to have it supervised, or can I turn up with my friend to pick up my children and my friend be the supervisor? This is what I want to know.
Good question.
The supervision should have been clarified and defined by the court as to what they mean by supervision, because sometimes they are happy to have a member of the family or a third party who can act as the supervisor. So without having sight of your court order, it's very difficult for me to comment on that, and I wouldn't want to comment and then land you knee deep in trouble by giving you the wrong advice. It is unusual for a court order to be in place where one party can essentially turn up with anybody. That is very unusual.
I was just looking at it, and it says interim child arrangement, spend time with order. The father should have supervised contact with the child every Saturday or Sunday from 12 to 3. Contact should take place at X, Y, and Z. Parties will best endeavour to agree time 7 days in advance. That's all it says.
And I appreciate you don't want to reveal it on this open line, but is X, Y, and Z a contact centre?
No, it's just a handover location.
Oh, okay.
Yeah, that's all it is. Because my the contact centre, they're impartial. They're known to the mother and works with the mother's sister, but they keep denying it. And I've caught them out red-handed so many times. It's come to the point now she doesn't even turn up. She sends someone else and she tells me transfer the money. And I've also found out from so my son said mother's been hitting him when he misses me. I've reported her to social services, but then the contact supervisor has gone and edited my contact report to say that she's added in the additional notes. Although Hamza said he hit him, we're not sure of the timeline when this happened because it's not the first time. So she's basically dumbed it down so mother doesn't get in trouble, and she keeps editing my contact reports. When I showed the supervisor that was there, I said, "Why did you write this?" She goes, "I didn't. Jenny wrote that. I'm sorry. The woman wrote that, and she wasn't even meant to. She wasn't even there for her to even comment on it." So she's very impartial, and I'm putting money in her pocket, and it's hurting my heart.
Yeah. I mean, contact centres is a whole conversation in itself. Okay. You need to formally approach the contact centre and say that I believe that the contact reports are not authentic, that they are being edited, or up to a point they are being manufactured. and they're not representative of what actually happened at the contact. Going back to the original point of can you turn up with one of your mates and collect the children? Well, from what you tell me in your court order, all it says is your contact has to be supervised. It's lazy order writing that they haven't defined what that means. Because as I say, when I hear supervised contact, my immediate view is in a contact centre, but you're suggesting that's possibly not the case. So I guess my view is, without sharing one way or another, is just tread carefully. Is the person that you're going to turn up with, is that person known to mother, and is that going to antagonise the situation?
I can turn up with someone that's not known to her.
Yeah, take a neutral person. Yes.
Do you know what it is? I'm happy to pay someone else money as opposed to this woman that's lying on my name. And these contact reports, I'll be honest, I've got 23 contact reports saying he's an amazing dad, knows how to handle his kids, no safeguarding issues. And when I give that to the judge don't care. So it's no point. I might as well just wipe my backside with these reports.
Okay.
So, yeah.
Tread carefully is. I think tread carefully is the answer there, Harry.
Shall I speak to my solicitor and see if they can shed some light on it?
I think you need some definition some clear definition about what supervised contact looks like before you end up, breaching it without even realising it.
Yeah,
Okay,
that's the
cool.
risk. You might breach it without realising it, and you end up back to square one. So I would just say, yeah, if you've got contact, try and get clarity, play the game, just tread carefully now.
And the other thing is, I spoke last time about mother not turning up with them. So legal aid has been adjusted, and I'm taking her for the C79 something 9.
Yeah, enforcement application. Yeah.
Thank you. That's in motion. Thank you, guys. I appreciate
Okay.
all the help, always.
Listen, before you go, yeah, did you say your missus watches this by any chance?
I think so. Yeah, that's why I'm a bit, because my YouTube subscriptions is for my children, and she's on it. So I think she comes and peeps over on my one to see what I've been up to. You with me? So I'm a bit scared. Even that last one I done with the loophole, I was like, shit.
Yeah, listen, man. So listen, but your name shows up on here. Yeah, this ain't your name, is it? Is Harry not your name? Yeah.
No.
Oh, that's right. So I could call you Harry. That's fine. Yeah.
Yeah, call me Harry. Everyone calls me Harry. Yeah.
Listen, if you're watching, this guy's Harry. Whoever's watching, you don't know this brother. He's Harry. No one knows Harry. So, guys, if anyone comes on, keep the camera off. If you don't want to be known, keep the camera off and put some funky name down. Yeah. But Harry, good speaking to you. Keep us posted. We'll be here next week. Keep us posted. Yeah.
I will do 100%. Have a good one. Yeah. I'm here anyway.
Nice
I'm in the comments. Yeah.
All right. Good man. Good man.
All right. Take care.
Right, guys, if you want to be fast track and you want your question fast track, like I said, click the link in the comments, come on live. It's just easier to answer back and forth, wrap it up. And look, there's new people watching right now. And some of you may have missed it earlier, but I just want to show you what was spotted in a car park. This was spotted in a Waitrose car park. No, there's people watching earlier at 18. There's 26 people watching. So those of you who missed this earlier, this Bentley was discovered in a Waitrose car park earlier. I wonder whose it was. And look, just check out the parking. Just check out the parking. Yeah, disgusting. I know. Disgusting. I know. Right. Move along. Right. My man, Darren. Thanks, guys. No worries, Darren. We're here for you. Right. Mr. Amp. Evening, gents. I had my federal last week. The judge ordered a Section 37 based on allegations of witchcraft by mother and police disclosure. What is the risk of S37 from the LA? Could the children do an adoption?
Well, goodness me, we've got lots of acronyms there. Okay, so let's break this down for everybody so we know what we're talking about. So I had my FEDERA. FEDERA stands for First Hearing Dispute Resolution Appointment. So it's the first hearing that takes place in a child matter in the family court. The judge ordered a Section 37. Now, it's interesting that the judge has gone nuclear from day one. He's clearly very, very concerned about what is going on here, because he has ordered a Section 37 report. Now, a Section 37 report is carried out by the local authority, LA. So he or the local authority will interview father, they will interview mother, they will go back to the police because there's been a police disclosure, so they will go back to the police and establish exactly what the police have got. They'll get that in detail. They will interview the children, and they will explore, and they'll probably go to the children's school if they're of child age. I can't quite remember. If they're of child age, they'll go to the children's school and talk with the staff to see whether the children are presenting with any issues. The issue of witchcraft is becoming more common in family court. I have a number of cases running at the moment. It is becoming more faith that has an element of witchcraft attached to it, and I make no more comment than that. But it is becoming quite publicly known now over here that witchcraft is followed as a theme. So the court has got no choice but to embrace it. So to answer your last question, so that's a Section 37. The judge has ordered it. It's got to have to be done. Could the children be faced with adoption if that Section 37 does not go well, and the social worker has a concern about mother and father? Then, unfortunately, care proceedings are the next obvious step, and there is an opportunity for those children to be taken into foster care. And ultimately into full-time care. That is absolutely not something that we would like. Well, that's the reality. So you're in a difficult position, and particularly as the judge has ordered Section 37 based on allegations of witchcraft by the mother. So I surmise those allegations of witchcraft are against you. Difficult position to be in.
Yeah, bloody ethnics, witchcraft and all sorts coming out. Do you know what I mean? Dealing with ethnics. Right, from Mr. Amp again. Also, are CMS able to take money from bank accounts and pensions if you're no longer working? If my savings are in crypto account, would they still be able to access the money? I think from my understanding, if you're in crypto, you're safe, yeah. But all the other stuff, if they're coming after you, they can gain access. But again, it depends on where you are with CMS. If there's no orders against you or they're not chasing you, then they won't just randomly do it. You'd be aware that they'll be coming after you, and you'd have to make your arrangements prior to that. What would you say, Mr. Ryan, to that?
Yeah, I don't disagree. Crypto is safe as houses. Pensions, they're very rare that CMS will try and break a pension. Bank accounts are, they can claim from bank accounts. If you're not working, that gives them a little bit of an obstacle that they've got to cross. But invariably, if you're not working, I presume that you're engaged with DWP. Possibly on universal credit or something of that nature, and CMS will just cross the floor to the universal credit department, which is just down the corridor, and say, can you take some money off this guy? That's how it'll work.
Mm-hmm. Right, Mr. Kudo's got a follow-up. No allegations were proven. Here we go. Do you remember Mr. Kudo?
Yeah, I remember Scudo. Okay, so he'd had a fact find, so no allegations were proven. That's interesting. Okay, because if no allegations were proven, the court is faced with something of a dilemma then at that point, because they can either still go down the Section 7 route just to get a view from CAFCAS, or the court can say, well, given that there were no allegations proven, that's it. Neither party has any bad blood, any negativity against them. So I'll now take statements from both parties to tell me what it is you want to do next. And we'll see whether we can thrash this matter out between us. So the judge has got those two options available to him. Pull CAFCAS back into the room or just carry it on without them. And really, depending on the circumstances of every case, will depend on which of those two routes they go down. I couldn't second guess yours. I would have thought at the end of the fact find, the judge would have given an indication as to where they were going to go with this.
Good stuff. Good stuff. Mr. Kudo, I hope that answers the question. If you've got any more questions, like I said, type them in the chat. Audio is fine. Thank you, Mr. M. Kudo, why did they say no contact? Right, Mr. Stray Dad. I had a call with Mr. Ryan last week, guys. Reach out, so knowledgeable and gives you that confidence and support we fathers need. Thank you. We'll call you next week. Yep, absolutely, guys. Get in touch. If you want him to represent you, if you want him to hold your hand, walk you through the system, 1-to-1. He will support you. It's worth every penny. Yeah, we know. Harry's been and gone, bro. Harry's been and gone. Darren, we're here too. Right, Lewis Hendricks. Thank you for answering my question, Mr. Lewis. This is why we are here. We are here to support you. Hold on, we've got a very important comment here from Mr. Stray Dad.
Oh,
Coach
no.
Farouk, beard game is on point, bro. Listen, man. Pete, let me tell you something about the beard, yeah? So originally, like I said, it was just a big mess, right? Yeah. Went to the barbers, and these days I didn't realize you could blend. I used to remember back in the day, short back and sides, and used to blend the hair and all that. I didn't know these days they blend the beard in and all of this, yeah. So I paid the guy 30 quid. He blended it all in, sorted it all out. The problem with the beard is, in about 3-4 days, it's gone, it's grown out. Like the stubble's come back. So then I thought, you can't be spending 30 quid a week. That's over £100 a month on beard. So I started practicing at home, watched a few videos. I messed it up slightly, but as this grows back now, I'm going to blend it in a bit better with this bit here. So it's getting there. I'm getting some new trimmers as well. But yes, you're right. It's not just a beard game, bro. I'm looking on point. All of this. This is no accident. This is no accident. And now that Harry's mentioned that women are watching this channel, I got to make sure I am on point. There's ladies watching. There might be ladies watching.
No, be careful. Just be careful. You know what happened last week.
Right, what does the court order say? Here we go, Sergio. This sounds like a new name, Sergio. If you're listening now live, we are here every week live at 8 p.m. Join in, and if anyone else is struggling, send them the link. Subscribe to the channel, watch the videos. Plenty of information on here. Right, my ex-partner is refusing to co-parent with me and has not let me see my children despite regular attempts to co-parent. I was in an abusive relationship and I reported it. My ex is I don't know. Okay, well, I don't know what that last bit means, Sergio, but just put in the comments below. But we'll try and answer the first part of the question.
Okay, so let's not worry about inging, whatever inging is. Welcome to the world, Sergio. To be honest, that your ex-partner is refusing to co-parent with you. Join thousands of others in exactly the same scenario. If it carries on and you can't get a decent conversation with her in order to be able to pursue it and obviously work in the best interest of your children, then I fear you're going to have no choice but to consider entering the family court to see if you can change the relationship there.
Okay. All right, Mr. Sergio, hope that answers the question. Looks like you have no court involvement at the moment. So I don't know how much contact you actually have or not with the child, but just give us some more details, yeah, if you could, and we'll see what we can do. Right, marriage called Judge Don't Care Classic. Yes, how can we resist the NMO renewal?
Okie doke. So obviously non-molestation orders last a year normally, sometimes 6 months, but usually a year. And obviously at the end of that time, the party who's holding them asked to have them extended. You resist it by convincing the judge that it is not for it to continue. Non-molestation is that one party is in imminent danger, an immediate danger. And if that's not the case, if that's not the case anymore because we've all moved on and life has calmed down, then the NMO is disproportionate, and we should share that fact with the judge.
Yeah, if you can demonstrate that, look, nothing's happened in a year except it's made your life upside down. Mother's under no threat. Ideally, they should not extend it. And I think in a lot of cases, correct me if I'm wrong, Mr. Ryan, but it is only in rare cases that it is extended. Did you catch that? Mr. Ryan, did you hear that? No. Yeah, he's got reception problems. Look, let's move along.
It.
Yeah, move your phone around or something. Yeah, your phone's playing up. Oh God. Yeah, we can see. We can hear you now. You're clear now.
Right, carry on.
Yeah, you're good now. You're good now. Yeah, with the NMO, I was just saying, it's in only rare cases that they extend it, really, unless there's serious threat ultimately.
Yeah, it is. It's the courts are getting less and less comfortable with extending non-molestation orders just because somebody's asked. They do tend to want to have some grounds against it now.
Okay. Right, let's move along. Crafty. Prince Harry or Dirty Harry? I think it must be a joke or something that we're missing here. Right, DGS. Can contact center costs be claimed as an expense with child maintenance services?
Yes.
Yeah. Oh, okay. Didn't realize that. Okay, fair enough.
Yeah, they can, and also your travel costs to the contact center can also be claimed.
Ah, see, learn something new every day. I didn't even know that. Okay. Right, Mr. Stray Dad, at Harry, be grateful for contact supervisor supported 23 sessions are great. I've only had 16 sessions in 1 year. Man, that's not even one full day with my boy. Stay consistent, bro, and strong. Absolutely, Stray Dad. Very good point. Always highlight the positives and the fact that you've had 16 sessions. I've had no sessions in over 3 years. I mean, I've not even had a phone call, not even had a picture. Forget that. I've not even had a picture or an audio, nothing. So listen, even 16 sessions is something, I suppose. But yes, good point. Amp, no, it's against mother, not myself. Okay, what was this question earlier? Do you remember? Let me go back.
The where it was the witchcraft issues. Okay, so the judge has asked for a section 37 because there are allegations of witchcraft against the mother rather than against the father. Apologies for that. Same principles apply. The same steps will be taken where the section 37 will be carried out by the local authority in order to understand what is going on.
Okay. Right. Mr. M, Google, if a paying parent fails to pay child maintenance, the CMS can take various enforcement actions, including sending them to prison for up to 6 weeks. I have to say, I mean, they say that, but I've yet to see someone actually go prison for that. Because if you go prison, you can't work, you can't pay anyway. So I think you got to understand, guys. I think what it is with the CMS, with the family court, all the lawyers and the letters, all the legal, there's a lot of scaremongering because the average Joe's not used to this sort of litigation. When he sees it, he looks at all of this, you read it, and it triggers you. You get scared, you get anxiety, and you fall in line. That is what it's designed to do, is scare tactics and scaremongering. That's why you've got to grab your balls in these moments and think, F this and screw you. What can I do? Let me fight it. Once you can just get past that initial shock, let the brain just adjust to that anxiety. Once the nervous system settles again, look at it logically and say, really, what are they going to do? What can they do? So a little bit of it is to just rely on that, your nervous system being triggered, you getting scared and getting anxiety and just start coughing up, basically, yeah? Right. Marriage causes divorce has clarified what ing means. It means emigrating. Or is he asking? Immigrating? I don't know. Okay, we'll deal with that later. Oh, here we go. Sergio's here.
Okay.
Sorry, I ran out of words.
There's a risk that one party is going to.
You what? Say again? No, Sergio's come back. Here you go. So he said he ran out of words. He said, "What court forms can I fill in to get access to my kids?" Right. I'll answer that. While Mr. Ryan's line is bad, Sergio, firstly, you need to fill in what is known as a C100. That's the first and most basic form. That's tier 1, first form that you need to fill in to get access to your children. It is a C100. Now, if you go down our videos, we've done a live where we go through and explain every single court form. So what I suggest, Sergio, is you go back through some of the older videos and start learning the language, start learning the system, get familiar with the court system, all the forms and documents. And the first video I recommend to you is the one that says, the video will say, Family Court Forms Explained. So go down the list of all the lives and the podcasts. You watch the video that says Family Court Forms Explained. And the form you need is the C100. And if you like Sergio, reach out to Mr. Ryan. I will put his email address in the chat towards the end shortly. Email him if you want support getting through this and submitting the form and the documentation. Reach out to Mr. Ryan and he can help you get you on your journey, get you, get the ball rolling, so to speak. Right, Amp. Thank you. I also need to show a schedule of allegations. I appreciate you are unfamiliar with my case, but what are the key points I should aim to add? Is there a limit of allegations I should include? It's a good question. Very good question.
There's no limit as such apart from reasonable. That's open to opinion as to what is reasonable. You're right. It's very difficult for me to be able to advise you on what a schedule of allegation should look like, having no knowledge whatsoever of your case. If you wish to, and again, I appreciate that I'm just repeating this, but if you wish to, my email is in the chat. By all means, drop me an email. We can have a bit more of a chat, and I can give you some pointers, because the schedule of allegations is the document that is going to take you forward through the rest of these proceedings. You need to get it right.
Right. I think at this juncture, I'm just going to put your email up so Sergio and Mr. Amp can see. info@mackenziepicavs.com, innit?
Yep.
Right. So let me just highlight your email quickly. Right, guys, the email's in the chat, and I'll also put it on the screen. Right, that is correct. info@mackenziepicavs.com. So, guys, email him. Email Mr. Ryan. He will arrange a call with you during the week, have a chat, and then he can guide you more bespoke, give you more bespoke advice to your case and your situation in private. Yeah, that's his email. Reach out to him, save it, get in touch. Right, Mr. Ryan, I just noticed the time, and last week I forgot to pray, so I'm just going to quickly hop off for 3 minutes and pray. Can you just take over, yeah? And we were up to here.
That's fine. That's fine.
Yeah, we were up to here, so I'm going to take this comment off the screen. You carry on with the next one, yeah? Okay, the next one is...
Yeah.
Okay, let me just go through these next few comments. Sergio, it's a C100. Yeah, Sergio, listen to the guys in the chat. They're helping you. Mr. W, hi guys. Hi, Mr. W. Sergio, I will probably take one. Yeah, listen, marriage causes divorce. This is not a positive thing at this stage. So I would say it doesn't matter. It might take longer. It might take shorter. We don't know. So it's best to give a guy positive energy and hope rather than, I don't know, that just comes across. It might put him off. You with me? Stray Dad, I resist a NMO with an undertaking, Mr. S. Right, let's move along. Mr. M. I accidentally breached my NMO, which I got taken to court for and fined. However, when she requested an extension, they didn't grant ex parte the NMO, and mine finishes today. I just want to say on that note about finishing your NMO, yeah, I think people, it sounds like it's nothing, right? Oh, my NMO finished. Firstly, I want to say to you that it's something that you'd say to a guy, congratulations. Congratulations, because to live under an NMO for 6 months and a year, 6 months and up to a year, and in my case, like indefinitely for 2 years and over, potentially, like the way mine was going, it is such a relief. And you got to understand, 6 months to a year disruption in your life, where you can travel, where you can go, what you can do, see your kids, all of this. This is a big adjustment to make. It's a big shock to the system. So listen, what I'll say to you, Hanifa, and anyone else listening, enjoy the day. You see that feeling you've got today, that feeling of freedom, the contentment, the joy. Listen, embrace it, enjoy it, go and treat yourself and go and celebrate. It's not like a minor thing, man. I remember when mine was lifted after 2 years. I remember the feeling now. Listen, so enjoy it, embrace this moment and celebrate. Right, at Stray Dad, my contact cost over £200 for 2 hours and it's very hard to afford. Yes, I agree. Right, Mr. Ryan, I'm going to leave you with this question while I quickly hop off. Yeah, guys, Mr. Ryan will sort you out. I'm just going to quickly pray.
No problem. Okay. Hopefully I'm in the ring. So, okay, guys, hope you're well. I've got a Kafkas interview on Thursday. How do we say that she's not agreed to the order from allowing me to have a family member present when I have my children? Right, okay, so I presume we mean by that mother has not said that she will allow a family member, your brother, your mum, your sister, whoever it may be, to be present when you have your children. It's always disappointing when one part is particularly disruptive or obstructive, and it's always incredibly disappointing when that happens. You have to engage with Kafkas and ask them if they will step in and be an arbiter for you. If Kafkas have no issue with the sister or the brother or the mother or indeed the father assisting you on contact, then they can make that position known to the mother in order that she is encouraged to participate. I trust it doesn't have to go to the point of going back to court in order to establish that mother, sister, brother, whoever it might be, is an appropriate person to supervise or be present in terms of being when you've got your children with you. You've said, and I'm just going to flick now to your Kafkas interview. You said you've got a Kafkas interview on Thursday. I don't know where you are in your process, so I don't know what that Kafkas interview is going to be, but I say the same things when it comes to a Kafkas interview. Recognize the fact that apart from what you say, which they are taking on board, it is also how you conduct yourself, and it's also how you present yourself that is going to give them the impression that they take away. And we need that impression to be positive, and we need that impression to be that you are the reasonable one. You're absolutely entitled to have an opinion. You're absolutely entitled to say you don't agree with something, but presenting that in a polite manner is a far better route in family court than being aggressive or being rude or being disruptive or dismissive. That is going to get you absolutely nowhere, aside from a reputation as being troublesome. So when dealing with Kafkas, I always say, try and be respectful. Try and be seen as reasonable. Accept the fact that they're doing a job, that they don't know either of you. You're perfect strangers to them, both of you. And they're waiting for one of you to convince them that you're the good one, and that's where we are in terms of Kafkas interviews. I offer the same advice time and time again. It's too easy to kick off and be disruptive and be obstructive and be rude and say it's not fair and the family court's not looking after me and it's favouring mother, etc., etc., etc. All of that is too easy. None of that is going to assist your position. That Kafkas officer can help you, or that Kafkas officer can disrupt you. I presume that all of us want the first one. We want them to help us. And in order to do that, we need to help them by being pleasant and respectful and reasonable, etc., etc., and engage in conversation with them. So tell them, this is why I think I would like this. This is why I think I would like that. This is why I believe this is the best thing in terms of the children. If you make those representations, whilst Kafkas may not entirely agree with all of them, at least they can see that you're giving some thought to the children, that you're being child-focused in your approach, which is absolutely important in terms of Kafkas. So that's I hope that's answered that question without me having too much detail to be able to move on. I'm just going to have a look at the chat now and see. Oh, look at that perfect timing. My colleague is back.
Are you done with that question?
Yeah, I've done that one. I was nearly in danger of starting another question, and that would be, I'm just not feel I've got that responsibility.
Absolutely. See, I'm glad you waited. Right. Does this answer the? Do you need this bit here, section 7?
Yeah, no, that's fine. That's fine. Yeah. It's
Yeah.
a section 7 interview. That's fine. I'd guessed that, so no problem.
Okay, fair enough. Right, Stray Dad, Mr. S at Stray Dad. By taking undertaking, aren't you extending it? I think there's a confusion between. Do you want to just touch on what an undertaking is?
Yeah, sure. When you get a non-molestation order application, you have two options. You have a number of options available to you, but in terms of the granting of that, you can either have it granted or it can be granted. In which case, and it can be granted as a non-molestation order, with all of the constraint that brings, or you can accept an undertaking to the court. Now, what an undertaking is in the simplest terms, it is a promise. You are making a promise to the court that you will abide by whatever constraints they then tell you they want to put in place. Don't go into the street, don't go near the school, don't go where she works or whatever it might be. Don't contact her on social media, etc. And you're making a promise, an undertaking, to the court to say, I undertake that I will not bypass any of these constraints that are being offered. So that's what an undertaking is. So are you extending a non-mol by taking an undertaking? You're not extending the non-mol, but what you are doing is obviously putting yourselves under a set of constraints for a further period of time.
Right, I hope that gives people some clarity on that. Mr. D, can the whole amount of contact center cost be claimed to CMS or just a percentage? Great question.
There is a section of CMS which is, and I can't remember for the life of me, and I'm racking my brains over the last 10 minutes. Can't remember the life of me what it's called, but it's called something like expenses, and there's another word attached to it, but I can't remember it. Must be the dementia. But you find that section which is called expenses, and it allows you to list costs that you have incurred, which can be travel costs, it can be contact center costs, it can be the fact that you're paying the mortgage on the family home despite the fact you don't live there, it can be the fact that you're paying all the utility bills on the family home whilst you don't live there, and all of these costs can be levied against your child maintenance in order for your child maintenance to be reduced accordingly, and so that you are making a fair contribution. As I say, search for expenses on the CMS website, and you should get led to it. It might be called allowable expenses the more I think about it.
Yes, check it out, guys. Check it out. Numero uno. The reason you don't hear about people going to prison is because, like you said, they're so effective at getting the payment. If you've got it, they'll just take it. No need for prison. Exactly. And if you're working and you go to prison, you're not going to be earning money, which you then can't pay anyway. So it's more, I just think it's more of a threat than anything. Right, Mr. W. Also, she asking to relocate, but she has breached so many times. My children were raised and born in London, and she does not follow orders. And because I have completed a DAP course, want to show CH.
Right, okie dokie. So she's asking to relocate. She's breached a number of times. Okay, she's born and raised in London, blah, 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 blah. All right. Okay. So I think you're in a position where you've got to wait for your next court hearing, haven't you, really? Unless you want to try and accelerate matters by making a C2 application and bringing these issues to the attention of a judge.
All right, I hope that answers the question. Let's move along. Mr. S. Now you just make a promise. So Stray Dad is saying to Mr. S, you just make a promise.
Yeah, that's an undertaking. You're making a promise to the court. Yeah.
Right, Mr. S at Muhammad, why didn't they extend her NMO even when you breached? Because I think when he breached previously, as he said, he accidentally breached it. That doesn't necessarily give grounds to extend it when the NMO ended. That's what I'm trying to say. So this is what I keep saying, guys. Don't always go in with a negative mindset. Believe that you're going to win. Start manifesting it, because negativity is a self-fulfilling prophecy. Yeah, and NMOs, even though we hear all these horror stories, it's not extended as easily as that. You know what I mean? Right, I'm gonna take this opportunity to highlight Mr. Ryan's email again. You want to speak to him directly in private, have a little consultation, case review, maybe just a couple of questions you want to ask and get some more insight and give him more detail. Email him, arrange a call. Mr. M. At S, I don't know why they didn't extend. However, my breach was verbal. I bumped into my ex and the kids, and all I said was, "Can I get the kids some clothes and toys for Eid?" Mother lied and got me nicked. So I would have presumed if she'd have started screaming and shouting, call the police, NMO, blah, 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 they would have come and arrested him, blah, blah, blah. He would have explained and they might have been released. NFA the following day, probably, I would presume, something like that. Amp, that's great. Many thanks. You're welcome. Right. I'm sorry to hear that. So when you paid the fine, it's a record now. All right. I don't know what that's about. Straight at, how do we go about claiming money of supervised contact of CMS and travel? I think the problem with the CMS is once you've paid it, it'd be very hard to get anything back, number one. But as Mr. Ryan said, on your application or where you log in or where you communicate with the CMS, there will be. Yeah, how does this work? I'm actually not even sure. Is there like that you go on your account online and then you can highlight these things, or how does it work?
As I say, you go into your online account, and there is a section in your online account, and the more I think about it, it's called allowable expenses. And you log with in allowable expenses the money that you're spending on supervised contact. They probably ask you to also attach a copy of a bill or an invoice so they can see obviously that it's true, that it's kosher, what it is that you're saying, and then they will make an adjustment on the payment because they accept the fact that it's not fair that if you are paying for supervised contact, it's not fair that you're also paying full maintenance.
Yep. So I hope that answers the question. Mr. M to Mr. S. Yeah, I've been charged for breaching. To be honest, the judge don't give a monkey because even if you say hi to your ex, that goes down as a breach. That's right. Listen, I just want to take this opportunity to highlight again. If you've got an NMO against you, yeah, don't try and be clever. Don't play games. When you've got an NMO, you lay low, out of sight, out of mind. You don't give them any opportunity. You lock in. This is a moment where you self-reflect. You lock into yourself. You lock in. You focus on what you need to do. You focus on your life. Take the opportunity to reflect on yourself. And when this NMO is over, how you plan to live, what you want your life to look like. Why are you in this situation? How will you make sure you never end up here again? This is a time to self-reflect. Get away from all the drama. Get away from the noise, lay low, eyes on the prize. Yeah, I think we forget this. Yeah, you got to understand, I lived 2 years in limbo, having no idea of what's going to happen next, if anything's going to happen, if this is ever going to be lifted. Now, in order to keep the mind calm and clear and focused, you got to go into some deep places, man. You got to do some real deep work. So understand what you need to do. This ain't a joke. Do you know what I mean? Right, where were we? Right, here we go. Right, Mr. S is asking at Mo, are you going for a fact find too? Yes, fact finds in August. Move along. At Mohammed, do you have a contact now? How long did you have to wait for fact find? Is it 3 days? Right, here we go. We got a question. Right. Marriage causes divorce. What happens if the mortgage and utilities is more than the child maintenance?
If you're paying the mortgage and the utilities, then you shouldn't be paying much child maintenance at all. You need to make the child maintenance. You need to make the child maintenance
correct. No, Mr. Ryan. Let me tell you. Let me tell you what happens. Yeah. If the property that you're paying the mortgage and bills for is solely in your name, that's not taken into account because they're going to say that asset belongs to you. So even if you're homeless and the kids and the family are living there and you're paying all the bills because you've got the NMO against you, you're homeless, They're living
Yeah.
in there because the property's in your name and you're solely in your name and you're paying. What CMS says, you're the beneficiary of that property. Hence, it's not taken into consideration. If the property's in a joint name, then they take it into consideration because she's also a beneficiary of that. If the property is solely in her name, CMS don't take into account you because you're the beneficiary of that property. That's what they say. Straight.
Okay. Well, I'll beg to differ on that, but because I've got a couple of clients who are paying the mortgage in place of child maintenance on the property. They own the property, mother lives in the property, and they're paying the mortgage, so they don't have to pay child maintenance. But anyway, but
Really?
I think there are circumstances around everybody, but it goes back to that whole issue of flagging at the allowable expenses what you are paying, and let CMS be aware of that.
Initially, this is what they said to me. Listen, I was paying for a few months until I lost my job and I haven't gone back. But initially, this is what they said to me categorically. They refused.
Yeah, no, I'm aware of your case, but
Yeah, initially, man, they were having me over for $1,000 a month, well over $1,000. You know what I mean?
I remember. But yeah, as I say, so that, in other cases, and as I say, unfortunately, this is the problem with CMS. They are inconsistent.
The problem with CMS, guys, this is what I'm trying to say. It is completely hit and miss. They're all over the show. Anyway, I don't like that word CMS. Let's stop talking about CMS. I don't like it. I hate these. I hate it. I don't want to think about it. Right. What happens if you breach the undertaking taken during the NMO proceeding? What happens if you breach the undertaking taken during the NMO proceeding?
The party who has the undertaking in their favour is entitled to go to the police and to say that you have breached an undertaking, and also they can then return the matter to the court as a breach of an undertaking. What will normally happen if you breach an undertaking and the matter is turned to court is the court removes your undertaking and simply puts in place the non-molestation order instead.
Bloody hell, yeah, there you go. Back to square one. Right, CMS equals contact CMS and apply for a variation. Right, WHH, I have had NMO for 4 years. How can I get this removed? Also, thank you. Be nice. I must ask for 50-50 contact as I had this before she breached the order, but since then had complete a DAP. Does that make sense?
Yeah, it makes sense. Okay, so you've had a non-molestation order in place for 4 years. I presume the court just keeps extending it because your matter is still going on, and it's just convenient for it to be so. At the point where your matter finishes, or you're heading towards a final hearing, you need to make an application to have your non-molestation order discharged at that point because it's no longer proportionate for it to be in place.
I hope that answers the question. Do you want to touch on the 50-50 contact and the DAP?
He's asking for 50-50 contact. I mean, the non-molestation order will not help without knowing the circumstances around the non-mol being put in place. But non-mol will not help in terms of a 50-50 argument, but it doesn't mean that you're completely lost.
Yeah, listen, you got to keep chipping away. Just keep trying. The key is don't give up. Don't get emotional. Treat it like a circus. Don't take it seriously. Keep chipping away. Holly's followed up with for the section 7. She could have said, hold on, I'm getting confused. So he said, but since then had completed DAP for the section 7. It's a bit broken up.
That's fine. That's fine.
All right, we'll pick it up shortly. Right, Mr. Stray Dad. Is a parenting planning together course good to do voluntarily if Kafka sent you a course via email?
Yes.
I suppose it will look positive, yeah. It will look good.
Yeah. Simple as that. Yes.
And if it doesn't, you're still where you are. If you do it, might get you some brownie points. So play the game. The key is play the game. Right, AMP. FYI, the mother was sitting in reception during my last contact visit. I quickly avoided contact and notified the management. Follow up with strongly worded email as she could have said anything. Exactly. Do not put yourself at risk. That's the right course of action to do. Do not take any chances. Do not take any risks. Record audio, video, highlight, get away, keep the distance. Don't give them any opportunity because that's what they want. They want you to slip up.
Mm.
DGS, in the next hearing, is it worthwhile to explain to the judge that my nearly 2-year-old daughter that I live with has yet to see her 5-year-old daughter? Doesn't my 5-year-old have the right to see sister? Good question.
I think they absolutely do. So it's worth explaining exactly that, worth explaining to the judge. About sibling relationships are important, and the court recognises sibling relationships. So yes, raise it as an issue.
Right, here we go. Straight out, if you breach an undertaking, will there not be evidence required in order for police to intervene or to issue a NMO? I think the short answer is no.
Yeah, quite. I mean, it's the court that issues the non-mol rather than the police, but no, often it can just get, because the family court, remember, guys, works on the probability of balance, so it works on how likely is it that this matter has happened, rather than how much evidence is there to support this matter having happened.
Yep. Right, let's move along. Let's try and fly through some of this. How long are DAP courses and which ones are available now? Do you admit in DAP courses?
Currently, how long's a piece of string? And the whole world of DAP is a mess. So rather than sort of jump into that now, because that would take hours, we will return to DAP at some point. There is some move afoot in the world of DAP over the course of the next allegedly month or two. Let's wait for that to unfold, and then I can make a definite position in terms of domestic abuse perpetrator programs.
Fair enough. Right, numero uno. Absolutely, the CMS do not have a clue. I agree. The CMS do not have a clue what they're doing. I agree with you. Nor does any other public body. I agree. Ironically, the court is the least worst. To be fair, court issues are normally because of the other clowns. I have to disagree with you there, Numero. The court is bad. East London court is worse. I mean, you have no idea. Let me highlight again, Numero. No. You have no idea the level of incompetency we are dealing with in East London court. I assure you, they are just as bad. Right. WH, in the interview with Kafkas, then I should ask for 50-50 contact. Should he ask for 50-50 contact in his interview with Kafkas? I don't think that's the place to be discussing that.
He doesn't ask for 50-50 contact with Kafkas, but he makes Kafkas aware that he believes it's appropriate that he has a 50-50 relationship between the mother and the children, and provides, because they'll then say, what makes you say that? And then it gives you an opportunity to provide your reasoning as to why you would like that to be the case.
Right, I've got a question on WhatsApp from a guy that watches. Now, I'm just quickly read it out. Just try and stay with me. Yeah, it's like War and Peace. Yeah. Right. Salam, brother. Quick question. On the 25th of Feb, on the first hearing regarding the NM, non-mol, which I didn't expect, mother made several false allegations. She managed to convince a neighbor that used to live downstairs to make a full statement, which she written on a piece of paper, and that was offered to the judge. The judge on the 25th said that would not be accepted like that, and she would have to make a formal statement, presented in a bundle, and will be prepared to turn up to court. However, the neighbor has now pulled out. Also, mum made a false accusation and said I was trying to kick her door through and she had to call police, which is incorrect. So the judge ordered mum to produce a police report, which she has failed to do because there is no report or any evidence to support criminal damage from the police turning up to her house. I have also presented pictures of the outside of the house and the front door, which was completely intact a week after she alleged that he kicked the front door. Also, mum said that she had to take antidepressants because of me, which yet again was a lie. I told the judge that she has a long history of mental health and was taking antidepressants because she was reliving the death of her father who committed suicide and was suffering from depression. And I just want to highlight in this case, the reason her father ended it is because he had an NMO against him and he never got to see his daughters, and the poor guy, that's how he died. That was this lady's father, ultimately, right? Right. Now, hold on, let's go back. The judge ordered mother to produce medical record over Spain in our relationship. Record over span in our over the span of their relationship. Yet again, mum has produced a letter from the doctor stating that this patient is no longer on antidepressants and is not a danger to a child. So what I'm asking, given all of this at hand, how serious would a judge look at her evidence now? She's lied all the way through a statement on numerous of things and being caught out. She also said I was on the run in 2018, which I've now produced evidence from a ROA to say that I've never had a warrant for my arrest throughout my life. The judge ordered her to make interim contact in February, and she has provoked and blocked every attempt to miss contact in the contact center. My solicitor and barrister have told me that her legal team should be telling her to concede. But what is the likelihood of everything at hand that she will concede and this will be thrown out on a pre-trial? My case is on Tuesday morning. Pray for me, brother. Brother, we are praying for you. And one more thing, I will be asked any questions at the pre-trial. Will I be asked any questions at the pre-trial, or will it just be down to my solicitor and barrister? Thanks again for all the help you have given so far. Right, so basically, how seriously is this going to be taken at this pre-trial, considering mother's been caught out on numerous occasions and proven to be a liar and has been discredited? Would you reckon? I mean, like I said, it's hard to say, but would you reckon?
The judge is going to be thoroughly unimpressed with this mother by the sounds of things, because it sounds like, aside from lying and trying to misdirect the court, this mother has also asked her GP to minimise her history in order that her past, and there's clearly is a past, her past is not revealed. You know, for a doctor to provide a letter that says she's not on antidepressants anymore does not answer the question that will have been asked by the court. So I'm quite sure that the judge potentially will ask for full GP records to be presented in order to remove the issue away from the doctor and their opinion. Mm-hmm. And I'm certainly quite sure that the judge will be, wholly unimpressed with what this mother has done. Answering the question about questioning at a PTR, no, you will not be questioned at a PTR. Your barrister and solicitor, one or the other or both, it's their job to do the talking at a PTR and to put this position over to the judge and explain to the judge that, the mother's conduct has been horrendous, absolutely horrendous, and the judge needs to take that into account.
Right. Okay. Listen, I hope this answers your questions, and I hope this gives you some hope ultimately. Stay positive, stay focused, stay calm, put your best foot forward, and just present the evidence, present the facts, and we will pray for you. Right, we got one more question from Amp. Forgot to mention, mother's family and brothers were sitting outside the courtroom. My barrister notified security. Would this be classed as intimidation and highlighted as abuse, or is this common?
Given that your barrister flagged it with security, and well done him or her for doing that, I would be saying that the judge will also have been made aware of it. And so, yeah, it can be regarded as intimidation. It's entirely inappropriate for an entire family to turn up outside the court in the hope that they're going to undermine you or distress you. So, yeah, I would regard that both as intimidation and as abuse.
Yes, do that, guys. That's a very good point. Highlight these little things. These little things can disrupt the other side. So this is good. Stand your ground. And also remember, intimidation relies on you being scared or being intimidated. If you don't get intimidated or scared, they got nothing over you. So grab your balls and front it out. So tell your barrister, tell the judge, highlight it as intimidation, get them thrown out, do whatever you can, to disrupt the other side. But the key is front it out, because when you don't respond to the intimidation, you show you're not scared. They've failed in it. They've lost. So do that. And got a comment from Stray Dad. Thanks, guys, for tonight. Always learn something new. Everyone stay strong. And my guy from America, Man of Steel, American Fathers. Hey, all. Thanks for all you do. Yes, we are here every Sunday. We're hitting it, supporting the fathers. Mr. Ryan, any final comments, thoughts, conclusions?
No, we've had a little wander around the family court this evening. We've touched on various subjects, which is always useful to do. I hope everybody has learned something from it, has picked something up to take away, because it's these little nuggets that come out of this chat, this clinic, that can prove invaluable to you. Again, anybody who feels they'd like to talk to me privately, you're welcome to contact me and do so. Failing that, we will head into the bank holiday, which is only hours away. I'd like to say the sun will shine, but there's no guarantee of that. But I will wish everybody a good week.
Yep, I think it's been a good stream. We've had good engagement. Guys, please like, subscribe, follow, and share. Send the link and the channel to those who may need it, those who need the support, those who need the information and knowledge. We are here every Sunday. We're doing it. We're delivering it every Sunday, 8 p.m. live. We will see you next week. See you in the next stream. Have a good bank holiday. Over and out. And 5, 4,